we all watched me lose my mind for an entire day on day 3 of the Baldwin trial. In the morning, I think I said something to the effect of, well, this looks like the defense throwing everything up against the wall to see what sticks, when they made their motion to dismiss. And then midway through the day, I went, wait, the judge might grant something here. And then by the end of the day, I was like, oh my God, what do you mean the other special prosecutor quit at lunch? And then by the time the case got dismissed, I think I just sat like a fish, with my mouth going like this, going, I don't know what to say. Like all day. It was one of the most unbelievable turns of events that I have ever seen in a trial. To get from day 1 and 2, where the prosecution was kind of trouncing the defense in the rulings that they got, we saw the defense miscalculate how much of Baldwin's statements would be used. And you saw the defense just scrambling, going, wait, that's not what we thought was happening. And then the next day, they like Uno reverse with that motion to dismiss, and the court grants a full hearing, and then everything changes. And it was stunning. It was unexpected. And the judge was like, no, I am putting my foot down. This is unacceptable fuckery. And the remedy for the unacceptable fuckery, which is the Brady violation, is to dismiss the case with prejudice. And then the court made an incredibly thorough record on that, and then brought the written order that we also covered together. The written order was scathing. The written order called out the crime scene technician and the crime scene technician's testimony, called out Special Prosecutor Morrissey, called out the fact that there had been other Brady violations already in the case. And the court went through all of the elements in that written motion and said, yes, this is a Brady violation. And the only sanction or remedy for this Brady violation is to dismiss the case with prejudice. With prejudice means it's done. Done. So when the court went through that order, the court evaluated, look, a jury veneer has been picked. A jury has been seated. Jeopardy has attached. This is coming up mid-trial. This is a Brady violation. There was testimony on the record that was not true from the crime scene technician. The prosecution already withheld reports of an expert from the defense. And now we're here, and they all opened up the manila envelope together, and the rounds that were not anything like the rounds on the set of Rust actually had rounds that were like the rounds on the set of Rust. And the court was down in the well with gloves on, looking at the ammunition. And then all of a sudden, there was body cam footage. And then all of a sudden, that supplemental report was under a whole different case number. And there was no notification in any of the reports that this had happened in a separate report under a separate report number. Yes, things can happen under separate report numbers, but normally there's a report that like bridges the gap between the two and says, hey, this is under a separate number for this reason. So we're noting the file on this case number that this thing exists on the other case number. That wasn't done. Kari Morrissey said she had never seen the report. And then she testified. And she was like, well, actually, Your Honor. And the judge was like, well, actually, nothing. I'm dismissing the case. Stunning. And the court told the prosecutors at lunch that she was inclined to dismiss the case. And Kari still got on the stand after that. And this motion, from the parts that I've gone over, and we haven't gotten to the law yet, she wants to relitigate these facts again and again and again. And then I was flabbergasted when Kari Morrissey was shading the judge in the response to Bowles's motion for dismiss. Bowles's motion to dismiss is a whole different situation. What Bowles knew or didn't know, Troy Teske being a Bowles witness, as it goes to Hannah, different situation. But in her response to that motion, Kari was like, the judge misunderstands and the judge shouldn't have dismissed it. And I was like, no, you did not. And now there is a full fucking motion of no, you did not. Ma'am, this is wild. I was absolutely stunned to see that Special Prosecutor Kari Morrissey has decided that she is going to actually file a motion for reconsideration. What are you doing? This was filed on August 30th, but this was not on the court website until late yesterday. 52 pages of a motion from Special Prosecutor. Oh boy, is it special. What makes it so special? Well, the lack of any law that allows the court to actually reconsider a motion to dismiss when the remedy given was dismissal with prejudice. Not a single citation that the court has exceeded the court's discretion to dismiss with prejudice. The court remedy of dismissal with prejudice is allowed under the court's inherent power if the court finds a Brady violation. And in the same motion, Morrissey says, yes, the court suppressed evidence. Yes, the testimony of crime scene technician Poppel was inaccurate, but that just because it was a mistake that it was inaccurate doesn't mean that it's false, among other alarming statements in the 52 pages of but Your Honor, I should have argued this when the motion to dismiss was before the court, but I didn't. So a month later and after it's dismissed with prejudice, I would like you to reconsider your ruling, even though jeopardy attached and double jeopardy doesn't allow for that. And the motion doesn't cite any law that would allow for that because no such law exists. And she says multiple times that the defense was sandbagging and that the defense knew about the evidence from Troy Teske, the rounds of ammunition that had been given to the Santa Fe Sheriff's Office. And the defense held on to that little nugget and sprung it upon the prosecution at trial to get the case dismissed. There's no evidence on the record that the defense knew what the rounds were that were in evidence. But even if they knew, the remedy would not be dismissal if the DA and law enforcement had turned that information over. There's no trap to spring if the prosecution turns over to the evidence that they're required to turn over. The prosecution continued to argue that this was basically all a setup by the defense attorneys and that they waited until the most favorable moment. And she said that the defense knew more about this evidence than she did, that she was completely unaware that it existed, that there was a report, had never seen it, and just didn't know. But also acknowledges that if it's in the possession of law enforcement, it is her obligation and duty to know those things, even if she does not actually know. It was a absolutely wild motion. Where do we go from here in the Baldwin case? Well, not to a retrial. This case has been dismissed with prejudice, but Kari Morrissey would like the defense to turn over what is likely protected work product information of how they knew about the Troy Teske rounds. It's giving Judge Glanville from the YSL case. Tell me who told you. These attorneys, Spiro, are going to do exactly what Attorney Steele did and say, no, I don't have to tell you that. It's work product. I don't have to disclose how we knew, because the person who's obligated to disclose evidence to the defense is law enforcement and the prosecution. The defense doesn't have to tell you how they knew. It's very, very interesting to see Kari asking for three things in this motion. One, the court to reconsider and to undismiss the case with prejudice, which can't happen. Two, the court to force the defense to disclose how and when they knew about Troy Teske and this evidence, who told them, and any documentation connected to it so that they can more fully make a record for appeal. That's not going to go well. And three, Kari Morrissey wants the court to rewrite the court order to not state that CST Poppel gave false testimony under oath and to not state that Kari Morrissey elicited false testimony under oath. But there's also an affidavit by CST Poppel where she says that the statements were inaccurate and not correct, but it wasn't intentional. So it's also acknowledged in the same document that the evidence is false. So where do we go? Well, the court could look at this motion and yeet it off the face of the earth and deny it as untimely as inappropriate and just strike it from the record. Or the court could allow the defense to respond, see if the defense asks for sanctions on prosecutor Morrissey for filing this motion, and then set it for a hearing. I wonder what the judge will do. And I personally am interested to see what the defense response to this is, and if they ask for sanctions, and if the court allows them to do that. Because the response on this is going to be scathing. The court's order against Kari Morrissey and the prosecution ruling for the dismissal of Baldwin's case was scathing. And Kari Morrissey coming into court saying, Your Honor, so we disagree with you. You are wrong. You interpreted everything wrong. I mean, we didn't turn over evidence, but that's not like suppression. But like, even if it is, it's the defense's fault that we didn't tell them about the evidence because they already knew about it. And the authority they cite seems to be because I said so. So we're not done with the Baldwin case, even though I thought we would be, because it's dismissed with prejudice, which means it's done. Wild. And keep in mind, when the defense asks for sanctions, depending on the amount of monetary sanctions against Kari Morrissey, it could require her to report herself to the state bar in addition to any reporting that she had to do for the court finding the Brady violation on her. So this is going to be a fight with these attorneys, I think. I don't think the court will strike it. She can, but I don't think that she will. And I am very interested to see what happens when the court goes for hearing with Kari Morrissey and Jason Bowles, where some of these similar issues come up, because the court will have read this before that hearing. So when this hearing comes up on the Gutierrez case at the end of September, I am going to be fascinated. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.